Kids don't belong in the driver's seat. How Utah custody law rewards defiance and calls it protection. Imagine that a court awards equal physical custody of two teenagers to a fit parent and to the co-parent. Nothing in the record shows that parent is dangerous, neglectful, or unfit. A few months later, the children stop appearing for scheduled time. The parent who has them says, "Well, I encourage them, but I cannot force teenagers to do anything." Eventually, that parent asks the court to change the custody schedule to match what the children are already doing and to increase child support because the fit parent is receiving fewer overnights. That outcome should bother you, regardless of which side of a case you may find yourself on. It creates a rule under which the parent who controls, encourages, or simply benefits from a child's noncompliance can profit from it, while the fit and innocent parent loses the relationship and pays more for the privilege. The honest counterargument must be acknowledged. A fitness finding is not permanent immunity. A parent's later conduct can damage the relationship. Some teenagers resist a household for reasons the original custody decision never captured. Not every refusal is manufactured, and some of it is earned. A sound rule must distinguish those situations from sustained non-facilitation. The problem is that courts often treat "the child will not cooperate" as the end of the analysis rather than the beginning. A busy judge or domestic relations commissioner has an institutional incentive to prefer the ruling that reduces immediate friction. Changing the order to fit the child's defiance may quiet the case, but quiet and correct are not the same thing. Teenagers are not toddlers. Utah law gives added weight to the wishes of an older child, but it does not make those wishes controlling. Family law cannot treat a teenager as mature enough to influence custody while also treating the same teenager as too fragile to experience any consequence for defying a lawful order. The solution is not physical compulsion, although physical compulsion should be on the table. No one should drag a child out of a house or force a child into a car as a regular course. The relevant question is whether the parent used ordinary parental tools, transportation schedules, phones, activities, privilege, discipline, and clear expectations. Courts should ask when the refusal began, what the child says happened, whether that explanation is credible, what each parent actually did, whether one parent quietly reinforced the refusal, and who benefits from the resulting status quo. Money makes the incentive problem worse because child support is tied to overnights. When one parent gains financially as the other parent's time disappears, the actual overnight count is not automatically a neutral fact. If the court finds that the deviation from the ordered schedule is attributable to a parent's failure to facilitate rather than to the other parent's conduct or fitness, support should be calculated using the ordered timeshare. That removes the financial reward without reducing what is available for the child's care. Sustained non-facilitation may also support a custody modification, but the court should require a documented pattern, not one missed exchange. The governing principle is simple. No party should profit from a wrong. Courts that treat a child's noncompliance as an act of nature will get more of it. Fixing the problem does not require being harsh with children, at least not necessarily. It requires being honest about which adult is actually driving the outcome.